First, a federal judge has unsealed the FBI warrant that authorized the search of former President Trump's Florida home. The document reveals the FBI recovered 11 sets of highly classified records from Mar-a-Lago on Monday. The warrant also indicates the former president is being investigated for possible violations of the Espionage Act. CBS News chief election and campaign correspondent Robert Costa reports.
The court papers obtained by CBS News and unsealed today show the FBI seized more than 20 boxes, some containing classified documents marked top secret and above. And according to sources, the material likely includes highly sensitive communication intercepts. The FBI also took handwritten notes, 2 photo binders, information about the president of France, and a document about the pardoning of Trump ally Roger Stone. The list of seized materials runs 3 pages. A federal magistrate approved a warrant to search the former president's home 1 week ago Friday, and on Monday morning the FBI executed the search. The warrant seeks documents related to the national defense, a possible violation of the Espionage Act, mishandling classified information, and also cites possible destruction of government property.
How did Trump handle classified documents?
John Bolton, now a Trump critic, served as his national security advisor.
Well, I thought he handled them carelessly. I don't think he fully appreciated the significance of the classification procedures.
The FBI was authorized to search Trump's office and all storage rooms or areas in which boxes or documents could be stored, which included most of the 17-acre estate. Guest suites were off limits. In a statement, the former president said the documents seized were, quote, declassified, and that he would have provided them if asked. On Capitol Hill, Republicans continued to voice concern about the FBI search.
And I want to know why they didn't just ask him for it. And if they did he not comply? I mean, that would be a very simple question to answer.
Democrat Jamie Raskin is a member of the January 6 committee.
Donald Trump is a one-man crime wave.
Trump's handling of classified documents has been the subject of a months-long federal probe, marked by a grand jury subpoena issued this spring, then a June meeting between investigators and Trump's lawyers, and now Monday's search.
Why do you think he took potentially sensitive documents back to Florida after the presidency?
Because he thought he could get away with it.
Legal wrangling will continue in the coming days over record classification. But as the warrant states, there are laws at issues here that have nothing to do with classification of records, but about how records were handled. Catherine?
Robert Costa, thank you. For more on the legal aspect of this FBI investigation, let's bring in Joseph Tully. He's a criminal defense attorney. Joseph, what does the search warrant tell you about the potential violations of federal criminal law?
So the search warrant is very perfunctory. It was very generic in terms of this search warrant compared with every other search warrant. The details that we were able to glean were that they were going after specific statutes, and in specific 793, which is the Espionage Act, 1519, which has to do with destruction of evidence, and 2071, which is removal of documents.
Could we see the affidavit that lays out probable cause also unsealed?
We very well could see that. Unless there's a national security reason, then it should be public. It should be unsealed, especially when the public has an overwhelming interest in seeing this. I'm sure media outlets will bring a Freedom of Information Act, freedom of the press, to get to this information. And again, here, there's a lot of back and forth. We don't know, it's like night and day difference. So it would be nice for the public to be able to see the actual information.
How broad is the president's authority to declassify records?
Well, it's very, very broad, and even more broad is the fact that the procedure is not standardized. So could a president sit inside a room and think in his mind or her mind that these documents are declassified? Yes, they could. So there's no set procedure. It's not like they need to be stamped this way and then marked this way. It can just be up to the president. However, I think that that's somewhat of a red herring, because when you look at the 3 code sections that the FBI cited in the warrant, none of those crimes crimes have anything to do with whether or not the documents are classified or declassified.
Let's take that a step further. Former President Trump issued a memorandum on the last day of his presidency to declassify the FBI's Crossfire Hurricane Russia records. Is it that simple? Based on what you're saying, it sounds like it could be.
Yes, it is. And that's what the president and some of his counsel are saying, is that, look, this was all declassified. But again, when you look at the three different statutes, the crimes don't depend on whether or not the documents would be classified. In other words, the President Trump could prove that everything was declassified, and it wouldn't matter for these particular statutes.
Let's drill down a little bit more on 18 U.S.C. 793. That's often referred to as the Espionage Act. Now, when you look at the language in the statute, it talks about taking and then losing defense, national security information, or using it in an effort to harm the United States. So it's not really about spying, is it? It's about something else.
Correct. It is about taking documents with the intent to harm America. But of the three statutes cited, the first two have an intent requirement where the government, if they were pursuing charges against former President Trump, they would have to prove that he had an ill intent toward America. And I think that would be a very difficult thing to prove at this time. However, the third statute, 2071, only has to do with removal. And again, classified or not classified doesn't really matter. It's there'd be no intent requirement, no intent to do anything wrong. It would just be the unlawful removal of documents. And if I was a defense attorney on the case, that's the one statute that makes me would make me a little bit nervous right now.
Well, a much lower threshold. Back to this issue of intent. If you think back 5 or 6 years, it was 18 U.S.C. 793 that was investigated with Hillary Clinton's private server, and the FBI director declined to prosecute on this basis of intent, right?
Correct, yes. And they had classified email threads that were classified, that were on her personal computer. And they also had millions of dollars being funneled into the Clinton Foundation, which all dried up after the Clintons left office. And the argument could have been made that they were selling, using the server like a Dropbox. It wasn't very secure, and if you put in money, then you could access the server. So, but that went nowhere. So it is certainly interesting times.
Joseph Tully, thank you.
Thank you.